So, good morning, good afternoon. I'm not quite sure we are together. Good morning, good afternoon. That's the spirit. All right. We had a first great morning session, 2 rounds. So we saw 4 teams, I guess, which were very dynamic, very combative, and part of the game really what we wanted to see. So we saw what we wanted to see, mostly two competing teams for each round, at least I participated in, and I trust that other teams, other judges as well, in other sessions will confirm the same. So in our evaluation, we use some 5 sets of criteria: the knowledge of law, the knowledge of facts, the way you are able to answer questions, and your presentation before, so the way you appear before a court, and the way you are organized. So I will be quick on each of those. For the facts, the knowledge of facts, it was clear that most of the teams have quite a fair knowledge of facts. And I'm using the word fair. I'm not saying great. Some were close enough to great. They could quote without even going to references. Other teams needed even minutes of silence to go back to the case in order to more or less find where the reference they are trying to make is. So when you have a 30 seconds gap or 1 minute gap looking for the facts you already invoked, that's problematic a little bit. So you need to show to the court that you took in your preparation great time to familiarize yourself with facts, and you can quote them, you can reference them without even reading. That's very important. The case was not very long. I think it's 12 to 10 pages, double or 1.5 spacing. That's not too much to master the facts. You need to have them at your hands. So for the law part, there was also a discrepancy. I mean, there is a lot of sets of laws that you can refer to, the principal body of law being IHL, but there were quite a few other references, ICTY, ICTR, both in terms of statutes or case law. But the way they were used was not always very clear for us. So that needs to be also very clear, the way you use the law and how you connect that to whatever point you are making. That was done sometimes better in some teams than others, and I will refrain from going into much more details in the spirit of the next round that we have. And the questions and answers. As a general rule, and that would be probably a tip for, I don't mind, for the last round, we have to ask questions as judges in order, first of all, to clarify things, to know how you answer to the questions, but also for another hidden reason that we not invoke here. But at least the point is that you need to be able to answer questions that are asked, but also, again, to connect it to the point you are trying to make. And here I'm again refraining from giving full tips to the finalists to be announced. But make sure that anytime you answer questions also, you are able to still use appropriately your time and be able still to make your point. So if you get lost in answering a question, you have a big trouble. And a few times we saw that happening. Not always. Some did a very good job also in connecting the two. But appearance is very important. The way you address the court, the words you use in addressing the court, the way you appear, the way you try not to threaten the court in terms of what decision they will take. I saw something close enough to that. You have to do these kind of things. So you have always, as a counsel, to appear to be very polite, and you are not ordering the court. In the end, we are the ones to take a decision in a case. So you are only, that's why we talk of, for example, prayer to the court. You are really praying the court to do something. We are not gods, but at least in that capacity, we try to almost act close enough to that as a court. But as you do so, also in terms of structure, the 5th point and organizational roadmap, most of the teams did a fair good job of announcing, for at least those we participated in, again, others will tell, in telling us from the beginning what they are about to do, how they divide their work, and what is the roadmap. It wasn't always very much followed in practice in what the submissions were, but at least you announced it at the beginning. That was very important, and that was good. But 3 things, when you are doing that, needs to be always the constant. You have the law. So in this particular case, you have the facts, you have the law applicable, you are using jurisprudence and so on, and you have the accused. In this case was Dextra. So you need to make really always a good thread of when invoking facts, invoking the law, and connecting it to Dextra for whatever point you make, whether you are prosecution or defense. And a few times we got quite contrasted, let's say, presentations from the parties. So that connection needs to be there, and the causal aspect have to be very much clarified. And it was not always key. Sometimes you presented amazing knowledge of law, but it wasn't very clear why is that relevant in whatever you are saying. So you don't connect that to anything and doesn't work. Last, from my side, in pleadings, across the whole presentation, opening and closing, there are 2 important things that need to happen. You need to present already some opening remarks at the beginning and tell us what you're about to do and how you are about to do it. And in the end, you have to tell the court what you want from that court. A few times, actually, we didn't get that from some of the pleading parties. So if you appear and don't tell the court what you want from the court, actually, you make our life very difficult to know what judgment we will render. That particularly the case, of course, if you don't do that as a prosecution, I'm not quite sure whether we can convict anyone if you haven't asked us to convict anyone, isn't it? If you haven't asked us to convict any person and you presented things and you end there, we are not going to do that because you didn't ask that as a prosecution. We are judges. We act upon what was presented to us. But you have to do that. You have to present some opening remarks or what we called a prayer. And a few times that was not done, and that is very important. So let me stop there, and maybe Sarah or you from the other side, please. Yeah, anything you can add?
Thank you. I think you've raised a good number of points that actually I had, but I want simply to emphasize on the teamwork. When you're in defense or prosecution, a counsel, you need to be working as a team. We found in most of the team, we find one person answering most of the questions and others seem to be very silent and they don't even seem to be searching or looking for the answer that is required. This is very important, we need to focus on that. Second, answer, and this actually leads to the unanswered questions and charges left out by the counsel. I don't know, clear reason. So you need to be using your time very wisely. If you have 7 minutes or 20 minutes, then you need to divide those 20 minutes in 4 or 3 charges you have, and then you remain with the minutes to answer some questions that you're asked by the judges. So this is very important. You need to put into consideration the time you have. The time is a very big constraint. You need to focus on that. So the application of law and the facts, you have already raised it. This is very important. Once you raise a case, you need to summarize the facts. What did happen? And some of the members of the council fail even to identify or immediately identify the parties to the case, which is very absurd. So this is very important. You need to be memorizing, owning the facts of the case and raising them immediately in a very summarized way. So having failed also to summarize the facts that were given some months ago, it is something that was not good. And in the eyes of the judges, you need to be confident enough, make sure that you summarize the case very properly, and you don't raise issues which are irrelevant or not convincing to the judges. Thank you.
Colleagues, any additional points, of course, yeah. Because it's very important, at least for the next.
Thank you. I think most of the points have been raised by my colleagues. Just advice for the next sessions, as Judge, in this case, Felix mentioned, focus on facts and know how to link it when you raise the law, applicable law, or a case law which defend your facts, but remember to make a link, because we had some cases where there were really good elements, good cases, but there is no link on which account are you referring to. So that's you must really be careful and be concise. The time that your facts are precise and you link with it the laws and the case laws and the other applicable law, it will make your point more understandable for judges. Also, I will come back also on the time management. Time management is very, very crucial, and I know it can be stressful when you see the usher showing 1 minute, 2 seconds, 30 seconds. You know, I know it can be really stressful, but when you have your time, you know, it's good that the all teams that we received at the beginning, the introduction, the way you do the partition, my counsel will use this minute to talk about this. It's okay, but put it in practice. There was one good strategy, I don't know, maybe the team can still use it. When you see, that's why you are a team of 3 people. If you see that it's the spirit of teamwork, if you see that your colleague, your presenting colleague failed to respond or to highlight what the point was raised by the judges, it's good that you just come to rescue, if I can say. Just take 30 minutes just to complete her or him, or 30 seconds, sorry. 30 seconds, you just complete what he was, you find that even the judges are not, even yourself, you are not satisfied, and you have a point. You can just support, compliment, and then go straight to your point that you were assigned to do. The one team did it. Unfortunately, the time management made that they took time on that completing a colleague, and he didn't have time to plead his own, and they conclude without making their plea. So for the next sessions, be careful and know how to manage your time. Appearance, yes, you have to be confident and showing that you are master of your facts, what you are presenting before the judge, and also being polite. In one case, there's one who was just pointing to judges. Please never do that. Okay, I know it can be sometimes, but you can. Sometimes I know people, even me, I like to do gestures to make my point very well, you know, understand. But you don't do that to judges. Judges, you should do this. No, it doesn't work that way. Okay, so but generally it was a good. Yeah, it was dynamic. It was very combative, and it was regarding the law, knowledge of law. It shows that you took time to read the facts. You mastered them. It's just a matter of now connecting facts to law and how now you present it. And when you also, another practical advice, don't lose yourself in the papers. That's a sign that you don't master the fact. If you know the facts, well, as my colleague said, the text is not really big, the case is not big. Even if we don't ask you to memorize from line 1 to the last, but when you are arguing, you know, have paragraphs, you know, don't find yourself, look at, and the 1 minute that you had is just 30 seconds already, you are not finding yourself in the papers. So those are the tips you have to take care of for the ones who are going to the next session. Thank you.
I know I can see Emerance is looking at us with some kind of big eye. So Charity, last few words, and then we go back to Emerance.
Thank you. I will not say much because most of the items were said by my colleagues. I will just focus on the procedural matters, how it was done. I mean, people were mastering the facts, the laws, but like they said, the linkage was really a problem. So it's good to master the laws and the facts, but again, if you don't present them well, it's going to be of no use. Because some people may have even written good memorials, but how they presented them was, you wouldn't wish to hear that. So what is that? The fear that you may have. So just one tip to give you is that instead of wanting to say out everything, you're just allocated 20 minutes. Please just try to be interesting rather than telling us or informing the judges everything. In case they're interested in a particular thing, they will ask questions. And when they ask, then you have all the time to answer what they've asked. But most of you or some of you were trying to I want to say everything that I've written or that I've read, which is not possible in the 20 minutes that were allocated. So rather seem interesting and convincing than bringing out everything. So another thing, if you're not sure about something, please don't destroy your own case. We had some people, you ask them a question, maybe they bring out a statement that is actually contradicting what they are saying. So just be sure of what you're going to say. If you don't know, just leave it instead of bringing in another controversy. Yeah. So, and another last comment that I'm making is that you have to be well attentive to what the other side says, if it is the prosecution or the defense. Because we had some cases, we had good practices and bad practices. The good practices, one group was following what maybe the defense or prosecution was saying, and then when they are to say something, then they will first react. But for some bad practice, one group would just say what they prepared without following the arguments. So please, you have to be concerned with that because it is important. Yeah, thank you.
Submissions from the defense for 20 minutes as well. After that, we will give 7 minutes to the prosecution for, or if it wishes so, for a rebuttal, and you have 3 minutes for a rebuttal. Now, without further ado, I give the floor to the prosecution. The floor is yours.
Honorable members of the court, I beg to begin afresh.
So keep that in mind, it's beginning afresh.
Your Excellency, thank you. Your Excellency, Mr. President, and honorable members of the court, my name is Kennedy Abuya. I'm the lead counsel for the prosecution. With your permission, may you allow me to introduce my co-counsels? Thank you. My co-counsel, Andrew, and third co-counsel, Mr. Ivan, or Counsel Ivan. Your Excellencies, in the course of our submission, we would like to spare our minutes as follows. Myself, as a lead prosecutor, I will use 6 minutes, 3 of which I will do the introductory or the preliminary matters of the case, and 3 I will submit on the first charge. Your Excellencies, my co-counsel Andrew will use 6 minutes, as well as my co-counsel Ivan, totaling to 18 minutes. We reserve 2 minutes for the questions from the bench. Your Excellencies, the accused before this court is one Commander Dextra, a citizen of Kundara, an adult of sound mind, who was having a commanding role over a rebel group called Freedom Forces during an armed conflict between them and their state army. Your Excellency, I would wish to classify the nature of the conflict as we found it imperative to set the bounds of this trial and the applicable laws. And on that note, we submit that the armed conflict between the rebel group Freedom Forces and the government army of the state of Kundara was of non-international character. Your Excellency, as a prosecution counsel, it's also important that we mention that this court has jurisdiction to hear and determine the matters before it, pursuant to Article 1 of ICTK statute. If it may please this court, may I proceed to the merit of the case? Your Excellencies, within the scope of the first charge.
Before you proceed, Counsel,
Yes.
said an armed conflict of non-international character. That was very quick. I was expecting it to be more than that. Why do you submit so?
Thank you, Mr. President. Your Excellency, we categorize it under an international armed conflict based on the thresholds or the test that we gave it. Your Excellency, for the record, we have tests that were given for the first time in 1986 by ICJ opinion on the conflict in Nicaragua that involved United States and Nicaragua. And ICJ says that for an effective control or total control has to be met before an international armed conflict or a conflict between state actors and the state army to qualify as an international conflict. Secondly, of the latest, Your Excellencies, we gave or we put against the test of the ICTY jurisprudence, that is the Tadic case, which was concluded in 2000, that not only the effective control, but it went ahead to clarify that there should be coordination and planning of the military operations by the state.
Counsel, for this court to know exactly what you are talking about, in terms of the jurisprudence you quote, could you very briefly tell us what you mean by, for instance, what are the facts of the Nicaragua case? Control of what? We are talking about what control, by whom, against what?
Yes, Your Excellencies, I would wish to refer you to the fact of the case. On October 2005, there were trainings by Kundai, the rebel group that claimed the Kundai liberation, and that was the Freedom Forces. They crossed over to the nearby country called Jamalin. After crossing over, one Madam Mugangavari provided the finances so that the state of Jamalin, or the government of Jamalin, could provide trainings and some weaponry. Your Excellency, we assimilate this to the case of Tadic in the former Yugoslavia. And this is where, in the appeals chamber, it stated that the level of the involvement by the state or by a foreign state has to meet a threshold of coordinating and planning. If we benchmark this to the case in Jamalin, we only find that Madam Mugangavari, who was a private citizen, is the one who gave the finances. The training and provision of weaponry, it was a one-time event. That does not culminate to coordination and planning of the military operations of the Freedom Forces, Your Lord.
Yes, please.
Counsel, you've argued why this is a non-international armed conflict based on the fact that it wasn't an international armed conflict. Could you now explain to us why this is a non-international armed conflict based on the fact that it's more than just an internal disturbance or tension?
Thank you, Your Honor. A non-international conflict occurs when a dissident group opts to organize themselves in a way that they can carry out a prolonged or a protracted military operations, and then with a source of command. We are referring it as a non-international conflict because if you look at the Freedom Forces, the threshold of organization is found that having them crossing the border and getting training and then coming back to attack, they were organized. They have a source of command, and that is why Commander Dexter is being prosecuted before this honorable court, that Commander Dexter had the role to command the court, the forces. Third, Your Honor, is that the period of the conflict was not within an hour or within a day. It is a conflict that went all the way. That is from 2005 up to late 2007, Your Honor.
You may proceed in view of time.
Thank you. Your Excellencies, I want to state here on the merit that the attack on 1st of December by Freedom Forces violated the customs and norms of war pursuant to Article 2, 4A, Roman 1, which we classify as willful killing. Your Excellencies, I want to submit here that by the virtue that this was the very first attack, IHL customary rules bound any party or binds any party to any armed conflict. 2, give precautionary, to take precautionary measures, and in furtherance, 2, give even a warning to the opponent army before launching an attack. Your Excellencies, I want to quote this from the customary IHL rule number 15 that emphasizes on the feasible measures and precautions that needs to be taken before launching any military operation. Your Honor, precaution might not be one of the principles of IHL, but I want to confirm here from a case law that its customary nature was confirmed in ICTY, sorry, I beg for the pardon, Kupreski case, judgment paragraph 492. That stated that precaution is a foundation from which other principles are inclined. Your Honor, this shows that by not doing so, it was a violation of customs and norms of war. Secondly,
Sorry, Counsel, you said that precautions are not a provision of international humanitarian law.
I'm saying it's a provision, but it is not a distinctive principles.
So you don't find a provision related to precautionary measures in the Geneva Conventions and their additional protocols?
Your Honor, I find it.
Okay.
And that's why I quoted rule number 15 of IHL customary laws.
And where can you quote in the additional protocols or in the Geneva Conventions?
In the additional protocol, Your Honor, I would beg that I consult, and then therefore I will give that answer when I'm doing my rebuttal.
Okay.
Thank you.
Proceed.
Your Honor, I also want to submit that Article 15 of the additional protocol 2 states that dangerous installations need clearly extra measures before striking. As an ordinary rule, we know that an oil depot with the inflammable nature of oil, it needed the freedom forces to take all what it takes before they launched an attack. And therefore, we find that as a violation of the principle of proportionality, and which states this way, that military advantage against which any operation wants to achieve must be weighed in the likelihood of any incidental loss of life. Your Honor, if there are no questions, I would wish to welcome my co-counsel to proceed to the next charge.
1 second.
Counsel, can you explain the consequences of the attack at the oil depot? So you're referring to Article 15 of Articles Additional Protocol 2. Can you tell us the consequences of that attack?
Your Honor, I want to state the consequences that the attack resulted in willful killing pursuant to Article 4A, Roman 1 of the ICTK statute. Your Honor, may I proceed?
Please do.
Yes, Your Honor, if I go to the definitional elements of willful killing, we find them in the definitional elements of 2002, which I refer to Article 2, B, paragraph, Roman 1, that the perpetrator needs not to have killed many people. Even one or more bodies qualify as willful killing, Your Honor.
Counsel, does it have any connection with the article you're quoting?
Again?
So you are quoting the article on precautions to be taken against dangerous installations. Does it have any connection?
Your Honor was quoting this one to qualify the willful killing, which is the crime under which we are prosecuting Commander Dexter with.
Okay. Yes, yes, please.
If you read paragraph 11 of the case, you find that it was a number of security and military personnel that were killed during the fighting, as well as a small number of the oil depot workers. From what I read, do you want to mean that when the military kills the military, it amounts to a crime? Because we see a few number of, yes.
Your Honor, that's, I would like to submit this way concerning that. In fact, on the fact of the case, that is 11 line 4,
yes,
that a number of security and military personnel were killed. At the same time, when you say, when we proceed, we find that a small number of the oil depot workers Your Honor, that's why I referred to the elements of crime to qualify the crime under which we are prosecuting Commander Dexter. And this crime specifically is willful killing. And I quoted that one of the elements is that we do not want to know how many people are killed, as long as it's one or two, because civilians are protected under IHL rules and laws.
And if I may, Counsel, so what is the exact nature of the charge? What are you charging Home for doing what?
I'm charging Commander Dexter by his acts of commanding the Freedom Forces to launch an attack, and then by his omission not to take precautionary measures before launching an attack, which resulted as the consequence of willful killing of civilian population that were working in the oil depot, Your Excellency.
Please proceed.
From here, if you allow me, I may call upon my co-counsel to proceed for the next charge.
If you have time, please do that.
Thank you.
Thank you. Mr. President, honorable members of the court, my name is Ange Nemeawahizi, and if it pleases the court, I would like to begin.
May I proceed?
Thank you, Your Honor. I would like to begin by presenting the charge number 2, by which we are accusing Commander Dexter on the crime of conscripting children of 15 years in the armed forces and to use them to participate actively in the hostilities. Your Excellencies, if you allow me, I would proceed by explaining briefly the facts. On 8th of January 2007, Freedom Forces commanded by Commander Dexter launched an attack on the Kundara National Stadium, in which officials and public gathered to celebrate the National Day. And during this attack, Commander Dexter used children of under age 15, and those children were seen even, some of them were as young as 12, as it has been reported by KTV reports. Your Excellencies.
What is the legal basis for that charge?
The legal basis for the charge of children conscription, it is, first of all, under the Article 4 of Paragraph 3C of the Additional Protocol 2, which states that children who have not attained the age of 15 years shall never be recruited in the armed forces or groups, nor allowed to take part in the hostilities. There is also Article 4 of the Convention on the Rights of a Child of 1989, I beg your pardon. And by doing this act, Commander Dexter also violated an important principle under IHA, which is the principle of distinction. He done so by launching an attack on a civilian object, which is the National Stadium, and it was full of civilians.
Counsel, remind me, what is the charge and that you are defending?
The charge, the main charge here, it is the conscription of children under age 15 in the armed forces and to have used them to participate actively in the conflict.
But Counsel, you seem to have just introduced a new charge when you spoke about directing attacks on civilians.
Yes, that is what I was explaining by saying that he violated the principle of distinction, but it is not the main charge. The main charge here is the conscription of children under age 15.
Counsel, are children who are participating in hostilities classified as civilians?
Thank you, Your Honor. children who are participating in armed conflicts are considered as they are just given the status of fighters, but not combatants, because this is not an international armed conflict. They will only be given the status of combatant if it was an international armed conflict. In this case, we have a non-international armed conflict.
Continue.
Thank you, Your Honor. Therefore, Your Excellencies, I hereby submit to this honorable court to adjudge and declare that Commander Dexter is criminally liable for the war of crime of conscripting children under the age of 15 to participate actively in the hostilities. With your permission, if there are no further questions, may I call upon my co-counsel to proceed with the next claim?
In view of time, yes, please proceed.
Thank you.
Your Excellencies, Mr. President and honorable members of the court, my name is Ivan Matata. I would like to continue arguing on the prosecution 3 on a count called sexual violence. Your Excellency, Commander Dexter is criminally liable of sexual violence, the crime punishable under Article 3 and 4 of ICT statute. First of all, I'm coming with the facts of the case. Concerning the case fact, paragraph 19, Commander Dexter Battalion push iron bars and bottles in private parts of women and girls. And Commander Dexter to be responsible, I refer on my co-counsel, Kennedy, has said that Commander Dexter has an effective control over the freedom forces. And also, Your Honors, by material element, case fact 19, it provides those acts. And even mental element is that Commander Dexter, as a command who had an effective control over freedom forces, knew that battalions of freedom forces are committing sexual violence, because basing on the incitement brought by Commander Dexter, he said that we are going to punish as Brigadier General Hilton punishes our men and girls. Immediately, the crimes of sexual violence comes subsequently, but before the incitement, they didn't commit those crimes.
Remind me, I forgot completely what your co-counsel said about effective control. So remind me again, from the facts of the case submitted here before this court,
yes,
it stated that actually we have a bigger commander above Dexter, who is General Mabuza. And I don't know now, I'm a little bit confused, who has effective control over freedom forces?
Your Honors, Commander Dexter, basing on the ICTY 30 case, Commander Dexter had an order and organization of whole army because he was the one on the battlefield and General Mabuza was not there. That's why Commander Dexter has an opposite side on the action carried out by freedom forces. Your Honor, by the link of the intention of Commander Dexter and the Freedom Forces Acts is that Commander Dexter, based on the Article 3 of ICTK statute, Commander Dexter as commander knew and didn't take all necessary measures to stop or to help the authority to bring those perpetrators before to be prosecuted.
You have 1 minute to tell this court what you want to tell the court in 1 minute.
Thank you, Mr. President. If to please the court, the link is there and the intention of Commander Dexter, based on Article 3 of ICTK and Article 4 of ICTK, Commander Dexter bears responsibility and as a commander of freedom forces for the acts committed by their forces. If there is no question, Your Honor, Commander Dexter and as applicants, I hereby pray to this honorable court to find and a judge that Commander Dexter is responsible for the crime of willful killing, sexual violence, and using children in armed conflict, acts punishable under the Article 4 of ICTK statute. Thank you.
Thank you, counsel. Now, the prosecution for the time being rests its case from what we can see. May I now invite the defense, if they wish so, to use their time. Depending on whether they want to, they can use 20 minutes as well to present their submissions. The floor is yours.
Thank you, Honorable Judge. Your Honors, I'm Pumwile Sharon. A counsel on behalf of the defendant in this matter, Commander Dexter. My co-counsels are Rugundana Elize and Mukanda Isenga, Virginia. I will highlight on the offense that was put across by the prosecution, that is count 1, using a period of 6 minutes. Co-counsel Virginia will highlight concerning the second count in a period of 5 minutes, whereas co-counsel Rugundana Elize will highlight on the third count in a period of 6 minutes. Your Honor, Commander Dexter is being charged by the prosecution for a war crime of willful killing. The defense submits that, first, the prerequisite element of intent is not satisfied in this matter. We base on the Blasky case, which states that intention exists where one acts with knowledge or the possibility of knowing that civilians are being targeted. Secondly, the Galich case also states that attacking with intent involves attacking consciously with one's mind on the acts with knowledge or the possibility of knowing that the civilians are being targeted. In this particular case at hand, it is visible that is paragraph 11 of the Moot problem. It is clearly visible that while conducting the attack, Commander Dexter directed the attack on the military and security personnel on the oil depots. When you look at the circumstances in which Commander Dexter directed the attack, he directed the attack to specific people, which he considered a threat to what he wanted to achieve. And hence, the intention of willfully killing the civilian population is not satisfied in this matter.
Counsel, is it your submission that directing attack against those particular targets is allowed under the existing rules of international humanitarian law?
Thank you, Your Honor. Under international humanitarian law, it is only the military objectives and the military personnel that are supposed to be attacked. But in this matter at hand. Even though the security personnel were attacked on one hand and then the military personnel, the prosecution has an obligation to prove that the perpetrator was aware of the status of the security personnel in the circumstances when he was conducting the attack.
Counsel?
Thank you.
Given the facts, it states that also not only the security personnel, but a few number of civilians were killed during that attack. And secondly, it was at the oil depot, so which means that I guess your client should have known that it's not a military object, the oil depot, so mean that there should have been also civilian and also the personnel who are not necessarily military. So how do you explain that?
Thank you, Your Honor. Your Honor, while conducting the attacks, there is always a possibility of collateral damages. Commander Dexter, while conducting that attack, took a precaution of choosing the specific people he wanted to attack. The small number of the oil depot workers that died or that were killed came as a collateral damage, just like any other. There is no attack that can happen and there is no collateral damage.
Counsel, could you enlighten this court exactly under the frame of the existing international humanitarian rules? What does collateral damage mean? Where does it fit in the rules?
Thank you, Your Honor. Collateral damage comes hand in hand with the principle of proportionality. The principle of proportionality states that what the armed group or the armed forces want to achieve should be or should not be excessive from the means that are used. In this particular case, it is clearly stated that a small number of the oil depot workers is the one that died, which implies that there were other depot workers, a big number of them. But since Commander Dexter directed the attack to specific people, it implies that the result of the attack did not exceed the military advantage.
Counsel, where in international humanitarian law do we find the provision of proportionality?
It is in customary international rules.
Would you like your co-counsel to give that information to the court?
Yes, yeah.
So, all right, you may proceed, and then your co-counsel would probably.
Additionally, jurisprudence confirms that the protection of civilians ceases entirely, is reduced or suspended when causing of the collateral damage is unavoidable. This is seen in the prosecutor versus Kuspreskik before the case that was before the ICTY in 2000. In this particular case, Commander Dexter took all precautions to spare the civilians. That is why a small number of oil depot workers died, which implies that the attack that was made, it was so hard for the collateral damages to be avoided. If I'm not of any further help to the court, I may call upon my co-counsel to proceed with the next count.
If you have time, you may.
Thank you.
With agreement from the bench.
Good afternoon, Your Honors. My name is Virginia Mkande Senga, and may it please the court. I appear as a defendant on behalf of Commander Dextra under a crime that he is being charged of by the prosecutor of using children under the age of 15. Before I continue, I would like to answer the question that you asked my co-counsel about the article that talks about proportionality, and it is in Rule 14 of the Customary International Law, Humanitarian Law.
Rule what? Can you
Rule 14 of Customary International Humanitarian Law.
So I see the person who asked the question. You may proceed.
Yeah, you can proceed.
Yeah.
First and foremost, Commander Dextra is not individually liable for the war crime of using children under the age of 15 to actively participate in hostilities. This is due to the fact that both the material element and the mental element are not fulfilled. For actus reus, perpetrator the perpetrator must have used children under the age of 15 to actively participate in hostilities. The prosecutor said that there was conscription of children, and only the conscription does not solely mean that the children were used in hostilities. They might be conscripted but not used in the hostilities. For the material element,
Counsel, could you enlighten this court? What does that mean exactly? They were conscripted to take pictures or something like that? What does it mean?
They might be conscripted as hostages of war or any other form, but not to fight, as they know it's not allowed.
Continue.
There was, as it said that on 8th January 2007, as there was a ceremony in the National Stadium, there are seen children in the stadium. There is no evidential link between freedom forces and these children, as there is no identification that links them to these freedom forces.
From what we can read in the cases, there were reports linking them to freedom forces.
Yes, Your Honor. The reports were there that were made by KTV. And KTV is a state-owned television or state-owned media. Being the fact that it was a state-owned media, and during the time of the ceremony, there are also other medias in the National Stadium. Other medias presented that there was an attack in the National Stadium, but did not clear say which party did the attack. And KTV reported that the attack was made by freedom forces. This brings us to a question: why is it that these other medias did not know which side of these children under the age of 15 were on, but only KTV? And this fact that only KTV said about it gives us the reason to say that it's not reliable. And another thing is that NTP is a regional unit, also reacted after the report of KTV that it reported this over the reaction because there was an attack in the stadium. It was an overreaction of KTV. And
Counsel, do you want to refute the credibility of KTV and then the NTF?
My Lord, I I
In
don't.
other words, wouldn't that be sufficient evidence that they conscripted and children under the age of 15 years and they made them take active part in hostilities?
Thank you, my Lord. By the fact that KTV reported this does not give it the credibility as an evidence, because there were also other medias in the National Stadium, but did not report that these children seen were on the side of Freedom Forces. And also, NTP as a regional unit that helped these people to come back together, as it condemned the report of KTV, also proves that it saw how biased it was, because it was a state-owned television. Commander Dextra is also not individually liable for using children. This is due to the fact that an individual is held criminally liable for a war crime when he or she personally committed the crime. And this is under Article 2, 3, A and B of the ICTK statute. As there are no evidences to prove that Commander Dextra committed this crime, then I would like the judges to take it into account.
The judges will take it into account after you reconciling what you are submitting with what the prosecution submitted, which was that he bears command responsibility since he was in effective control of his forces. That's what the prosecution submitted.
That's
so
right.
What do you have to counter to that?
That is right, my lords. But according to these facts that we've seen, and due to the fact that both the material and mental elements are not beyond measurable doubt, they are not beyond measurable doubt identified.
What is that? Beyond measurable doubt? What is that?
Both the material element and mental element are not fulfilled. Since they are not fulfilled, Commander Dextra cannot be liable, should not be liable of this crime of using children under the age of 15.
So do you mean that Commander Dextra is not liable for the acts committed by his late? Is that correct?
Yes, Your Honors.
And what's the ground for that?
This is due to the fact that the prosecutors did not present the evidence to prove that Commander Dextra knew that Commander Dextra knew that these children were under the age of 15 or they are used. If there are no other questions to be held.
Counsel, you're not answering my question. I'm asking whether Commander Dextra, you're arguing whether he would not be liable for acts or offense committed by his men and women in uniform. Is that correct? Is that what we are arguing about?
Go ahead and I listen to the question again.
Commander Dextra does not bear any command responsibility in this case? That's what I'm asking you.
Yeah,
thank you.
Maybe to add on what he has said, to complement, does it mean that a commander is not responsible for the acts of his subordinates, because that's what you're trying to advance?
Thank you. But the prosecutor presented that Commander Dextra should be individually liable. And here I'm trying to cut out how he is not individually liable for this act.
Counsel, if we go to Article 2.3b of the International Criminal Tribunal for Kundara Statute, it says that a person can be held individually criminal responsible, not only if they commit the crime, but also if they order, solicit, or induce the commission of such a crime.
Thank you. Due to the fact that we have seen that both the material and mental element of this crime are not fulfilled, then we might conclude that Commander Dextra did not commit this crime and his fighters did not also participate, and these children under the age of 15 were also not under his command.
Thank you.
Okay, let me proceed.
May I call my co-counsel to come on and present another?
If you can do that in 3 minutes, yes.
Thank you.
Thank you, Your Honorable Judges. I am Rwanda Irize. If it may please the court, I would like to proceed with the third count. But allow me, before proceeding with the third count, clarify some of what my co-counsel has been saying. Has been saying that there was no recruitment of children because, as it is known, when the Freedom Forces was being formed, there was a recruitment of voluntarily men and women who have been voluntarily recruited without prior military experience. As we proceed, is that Commander Dexter had full details about the members of his forces. That is why there is no children. The credibility of KTV is somehow is too low, unless it corroborates with other evidences that the prosecution failed also to provide. As I continued about the sexual violence, the prosecution submits that the requirements for command responsibility by Commander Dexter are not fulfilled because the superior subordinate relationship of effective control requires is the power of the superior to control the action of his subordinate. According to Prosecutor versus Braskich, in paragraph 335, if the superior has no power to control the actions of his subordinates, which is very similar to what Commander Dexter had, is that there was no power there was no power to control the actions of his subordinates. Second is that as a commander, Dexter had no knowledge because of the standard of knew or should have known the commission of the crimes. Commander Dexter did not have knowledge about the commission of the crimes, as Freedom Forces controlled 70% of Kundai. So he was not.
You are conceding that Freedom Forces committed sexual violence crimes?
They may, yes, even if they have been committed. The problem here is about the command responsibility of Commander Dexter. So if he did not know and should not have known, owing to the circumstances, he was not in a position to know that the crimes were being committed or were about to be committed.
Yeah.
So, I see. Yeah. Yes.
Okay. Can you tell us on which legal basis that the knowledge of the chief commander of what his subordinate his responsibility?
Your Honor, there is an inspiring case law of Prosecutor versus Harolovich from the ICTY in paragraph 65, where it says that it must be proved that the superior had actual knowledge of that his subordinates were committing or about to commit the crimes within the jurisdiction of the tribunal, or that he had in his possession information which would at least put him on notice of the risk of such offenses, and such information alerting him to the need for additional investigation to determine whether the crimes had been or about to be committed.
Fortunately, you have time. You have 1 minute.
Counsel, I want to ask you one small question on the command. The commander Dexter has a force, and he commands the force up to the grassroots, to the section level. Do you mean that he was not in position to know what is taking place in other areas under his control?
You have 45 seconds.
Your Honor, as it has been discussed before, during the course of military operations, sometimes as a battalion, which controlled 70% of Kundai, some people may carry out the crimes, but as long as they not take part as a tactical method to carry out the attacks, he may not be aware. He was not aware about those crimes were being committed. They have been committed, but he was not aware of those committed. Because if, as a subordinate who knew that if he's caught committing those crimes, will be punished, then there will be the trouble. And he avoided anything that would put on the extra or notice that there is the commission of the crime. Your Honor, may it please the court to submit the prayers for relief of the defense. The defense, considering on the rules and evidence stated above, the defense humbly requests this honorable court to adjudge and declare that Commander Dexter is not criminally liable individually to willful attack against civilians or using children and conscripting children under the age of 15, and not criminally liable as a commander for committing acts of sexual violence, in particular rape against civilians.
Thank you, Counsel.
Thank you, Your Honor.
Now, we have had initial submissions from both parties. Now, the prosecution has 7 minutes to rebuttal if it wishes so to do so.
Your Excellencies, President, Mr. President, and honorable members of the court, I'm here to rebuttal the defense side. First of all, by principle of precautionary principle, and also by the Article 13 of Additional Protocol 2 to Geneva Convention, forces commanded by Commander Drexler violated the principle 15 of an international humanitarian law in custom of the war, where if the forces commanded by Commander Drexler didn't access and do the assessment if there are civilians there, those few workers, they will attack, making a warning that the war is coming, because the forces from the central government, it was the first attack on them. The forces of freedom forces might go there warning that the attack is coming, and the situation that didn't happen there. And also, on the second account, on the using children in armed conflict, Commander Drexler bears act of using them because by the fact of the case, there was a report from KTV, and the respondent said that there were so many other medias which is not in the fact of the case. The media that we know in the fact of the case is KTV, and also the national platform, national together platforms didn't decline that there was a use of children in armed conflict. And also, the question remained on the part they are fighting for. And definitely we found in our case that Minister of Defense has died, and the government cannot train the children to kill their officials. It means that also in the rebels, it is usual. They fight without appearing in the uniforms, but the national platform, together platform, notified that there was a use of children in armed conflict that Commander Drexler has to bear. If it pleases the court, I can pray that and ask the court to declare that Commander Drexler is criminally responsible for those crimes. And if there's no question...
Which one again? Which crimes?
2 crimes, willful killing and even using children in armed conflict.
Okay.
If I may continue, I can call my...
So, We'll consider indeed
yeah.
his responsibility in those 2 crimes.
Thank you, Your Honors.
So, okay, so you are dividing your time indeed, okay.
President of this honorable court and the members, I want to rebuttal very quickly. And I also want to add that we also indict Commander Dexter with the war crimes of sexual violence, in addition to the 2 that my co-counsel has mentioned. Mr. President, if you allow me, may I proceed for a brief rebuttal? Let me make, I was asked a question and I said that I would come back to it. The principle of precaution. Yes, as my colleague has mentioned, he has mentioned Article 13 of Additional Protocol 2. It's all about precaution. And then the second protocol to Hague Convention, then the principle of precaution is also well embedded. So it has gained the customary nature. Now, there was a submission from the defendants that the mens rea has not been established by the prosecution. Your Honors, if you allow me, I would refer the defense counsel to trial chamber. That is on September. That is prosecutor versus Jadi. That is this September 1, 2004, paragraph 386. And here I quote, if you allow me, that for establishment of mens rea in the case of willful killing, either dolus directus, which means the direct intent, from which, from my interpretation, I believe the counsel for defense was referring to, or dolus eventualis, meaning the indirect intention. That either of the 2 is sufficient to establish it. Now, in this case here...
And that's jurisprudence from where again?
It's trial chamber, ICTY trial chamber, September 1, 2004.
If you may enlighten this court, this is the International Criminal Tribunal for Kundara. How can we use that? It's not from this court.
Yes, Your Honor, the decided cases or jurisprudence form the sources of the law. At the international level, we would submit that the cases of similar nature that were decided with related merits are or can be quoted to determine or for persuasion in the judgment for the case like this one before you.
Would there be any source for that, for submitting that? Any legal source?
Yes, Your Honor. The legal source is that when a case is decided, it becomes binding for the previous, it becomes binding going forward for the other cases of related nature, both at the international or both at the domestic legal system and at the international legal system.
So international courts have to, the cases decided by X international court is binding for other international courts and for national courts?
Your Honor, it can be used depending on the hierarchy or depending on the levels of the cases alleged.
In view of time, please proceed.
Yes. Also, I want to say that the collateral damage, as alleged by the defense counsel, does not have any effect as far as charge of willful killing is concerned. Your Honor, if I refer to my previous submission, I quoted Article 8.2b, Roman 1 of Elements of Crime. That states that we do not want to know how many were killed as long as there was cause of death of one person and more. They also raised the question of the material element concerning the conscripting of children. Your Honor, I want to submit that there was no contest or contestation on whether children were recruited or not. Even if they say KTV was biased, but we have a confirmation, if you go to the fact number 14, the last 2 lines, that the NTP observers actually confirmed that the children were used during the attack. I want to clear the doubt that they mentioned that it was not known from which side they were fighting for by submitting that the children actually were involved in the hostility at that point. The casualty were government officials and a few civilians who were there to commemorate their constitution. Your Honor, in a natural reasoning, it goes without saying that the state could not recruit children at the same time fight to kill their own officials. Your Honor, at the same time on the superior and subordinate responsibility, I want to submit or contend here that it is not only the superior and subordinate responsibility that we are going to charge Commander Dexter of sexual violence, but I will refer the defense to Article 3B, Roman 3 of the ICTK statute that shows that if he had he was not in a position to know.
You have 30 seconds.
Yes, thank you, Your Honor. He never took any concern, therefore he still have responsibility because he was supposed to bring the perpetrators to book. Your Honor, if you read fact number 19, last line, instead of bring the perpetrators to book, he said that let them continue and spread the message of one Kundai. If it so please the court, I hereby submit our final prayer as a prosecution that may this honorable court find and adjudge that Commander Dexter is criminally liable for willful killing of civilians, 2, for conscription of children to participate in hostilities or in armed conflict, and finally, of sexual violence by his omission. Thank you.
Thank you, counsel. The defense, you are entitled to 3 minutes, no more than 3 minutes, to give us a rebuttal if you wish to. So I see you on your feet, so please take the floor.
Thank you, Your Honor. It's a privilege to come back before this honorable court to clarify and to try to give the reason of not considering the submission of the prosecution, because the prosecution has submitted that Dexter is being accused of willful killing of civilians. Yet, willful killing of civilians is applicable in international armed conflicts. It's a rule 156 of customary international humanitarian law and is part of grave breaches. And it is beyond dispute that grave breaches are applicable only during international armed conflict. And prosecution has started by qualifying the nature of armed conflict as non-international armed conflicts. May it please the court to proceed by saying that the principle of the precaution of the attack is the rule 15, that all constant care must be taken to spare civilians and civilian objects. In our case, Commander Dexter, by launching the attack on the major oil depot, he took all necessary and reasonable measures and chose to hit the military objective and tried to spare by avoiding the civilian, by avoiding the killing of civilians, which unfortunately happened, but not as the intention, but not as the result of intention, but as the result of attack as a collateral damage. If the prosecution was submitting that there was excessive civilian killed, it should have proved how much is too much.
But, counsel, the prosecution in the very last submission submitted that still the Dexter did not take any measure at all to punish those who committed crimes. Based on your submission, you said he was not responsible. So any answer to that?
And secondly, the prosecution said that, submitted that Commander Dexter did not take any measure before the attack.
Those two,
Your Honor,
in 1 minute.
Your Honor, Commander Dexter took the measures and chose to hit oil depots which provided fuel to Kundara armed forces, and this was intending to bring about a concrete and military advantage so that you may proceed. When it comes, as Your Honor, if it may please the court, may I proceed with this this last count of sexual violence. This sexual violence requires 3 requirements: that the superior subordinate relationship exists, and that the accused knew or should have known the commission of the crimes, and that he failed to submit or punish the crimes. Commander Dexter was not in a position to punish because also was subject of internal disciplinary action because of what he was being suspected. Your Honor, may I conclude by saying that?
Counsel, if I can just interrupt, customary law rules, do they apply only to international armed conflict? Are customary law rules only valid in an international armed conflict?
Your Honor, customary in international, they are binding.
When?
And they are binding along with the conventions.
Binding when?
In which type of conflict? Basically, that's the question of the Honorable Judge.
In all armed conflicts, customary international humanitarian laws may apply.
Thank you.
Yes. May I conclude by submitting that the defense submits that and requests that the willful killing be not considered because of its application, and that Commander Dexter is not liable as an individual and as a commander for the crimes of using children and conscription of children in armed conflict, in armed forces, and not liable as a commander for sexual violence, in particular rape. Thank you.
Thank you, Counsel. May I take your seat? Counsel for Prosecution, Counsel for the Defense. This court did take your submissions and did hear very carefully and thoroughly your submissions. This court will now take time to deliberate and go through a very long process of writing a judgment, and we will inform you very soon in the coming days about when the judgment will be rendered. And with that, we thank you for your submission and for your time, and I declare this court adjourned. All rise.
So, Mr. Maximilien Zeimana. Marie-Ange Nemea-Bahisi. Ivan Matata. Derek Sankara. Patience Kamanzi. And last but not least, Eve Uwera. No, Eve? Oh yes, I remember. She had to leave earlier. We will proceed to another category of best speakers. This year, the organizing committee concluded that we'll have a best speaker from each team that participated. So we will have 3 best speakers, and the 4th one will be the overall best speaker. We have from the team of University of Kigali, Doreen Kazarwa. The best speaker for the team of UNILAK, George Hinga. And the best speaker for University of Rwanda is Sharon Pumwile. And the overall best speaker is Kennedy Abuya. We are also awarding the overall best memorial. That's prosecution and defense combined. And the winner is the University of Rwanda. Yes, all of you. And finally, the moment we've all been waiting for, our winning team for the 2nd edition of the Icrc Moot Court competition for this year is the University of Rwanda. Congratulations. Okay. Okay. Thank you. You may have your certificates as well. Okay. Please, all team members join in for the group photo. She's going to give some advice to the winning team. It will just take 3 to 5 minutes. And then we will have our cocktail to celebrate. Thank you.
Yes, hello? University of Rwanda? Sharon? You're going to Arusha on Friday? Would you like some advice from a former judge in Arusha? Okay, so let me give you my advice. So the first thing to take note of is that I think you all did excellently, as Emeran said, compared to the first edition of this Moot last year. I can see that the teams have been working really hard for this year, so well done. The one thing we did notice, though, is both the defense and the prosecution, in the final, you all acted much more nervous than you were in the preliminaries. Is that true? Were you more nervous? So we could see it. Okay, so I really want to encourage you. The one thing that goes when you get nervous is your passion. In the preliminaries, both of these teams were very passionate about what they were saying. You could see that what you were arguing, you really believed. And in the final, we didn't feel that as much. And that's going to be very important in Arusha. Okay, so feel passionate about what you're saying, be confident even if you feel nervous, and convince the judges that what you're saying is absolutely what you believe. Okay. The second thing is that you're going to need to be a bit more flexible than you were in this Moot court competition. This Moot is quite formal, the way that we do it. In Arusha, it's very informal in certain ways. You do role-playing, okay? So one day, you might be pretending to be the rebel commander of a non-state armed group. Another day, you might be pretending that you are an Icrc delegate. Another day, you might pretend that you work for the Ministry of Health of a government in the midst of a war. So you're going to need to be very flexible and be able to change exactly what you're saying and how you're saying it on the spot, okay? So that's going to be a bit different from the way that we did the Moot here. The other thing that I wanted to say is that it's wonderful that you all speak so clearly and beautifully, but you are going to need to speak faster sometimes, okay? Especially in Arusha. So you have very short time limits in Arusha, shorter than what you had here. And when a judge says to you, you have 30 seconds left to convince me, don't and don't look at your paper, don't speak slowly, speak as quickly as you can, and get as much into those 30 seconds as you can. Okay, and we didn't really see that today. I think the last thing that I'd like to say is just to commend both groups on certain things that we saw in the final that we'd really like you to take with you to Arusha. So the first thing is your respect for the court, but also your respect for your co-counsel on both sides. That's very important, and I think all 6 of you did that excellently. The other thing is that your time management certainly improved since Felix mentioned it in his comments after the preliminaries. So well done for listening to that. Time management is vital in Arusha. I also felt like you weren't scared of the questions. You're starting to actually embrace the questions, which is really important. If you think I was mean, or if you think we were mean, wait for Arusha, okay? So embrace the questions, see them as valuable. Don't see them as an annoyance or an interruption. And that is all that I have to say. So I wish you all the best for Arusha. Do Rwanda proud. And we hope to see all of the students who are here as competitors today. We hope to see you back next year at the 3rd edition of the Moot, supporting your teams and acting as mentors for the teams that come after you. Thank you.
Good. I would like to thank everybody. First, the students for making the effort, for putting in the energy. You're all winners, particularly you, but you're all winners because you will all have learned something. The faculty and the coaches for preparing the teams, the judges for giving your time and being with us here today. I used to be several times at Arusha, more as an observer and a co-organizer. And it's just beautiful to see that there is now here a tradition starting as well, which feeds into this. For us, this is incredibly beautiful to see beyond being important. It's important as well. So I wish you all had good 2 days. Thanks for everybody, and enjoy a drink, I think, right? Good. And for those who travel well to Arusha. Take care.